की नजरों ने देखा प्यार no songs no Bollywood songs he says mantra can I ask you
wait
mantras
IIFA again
Hari Om Hari Om Hari Om Radhe Krishna yeah ready
IIFA don't forget IIFA
Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us my partner David Nachman. David, thank you.
Thanks so much, Michael. Pleasure
and
to
we
be
have been
here
talking
with you.
about thank you, and we've been talking about IIFA in the last few programs. We want to give our viewers the information about IIFA. Basically, a lot of them already know what IIFA is. And as we have been telling, it is going to be done this time, first time in the United States, in Tampa, Florida, in April end. So people who are interested, some people that we have already contacted us. And the question here is, how can they buy the tickets and what is the importance of, why should they come to IIFA?
Well, I guess the first question is, are they coming from India or are they coming from the United States?
Because basically, we are talking about our viewers in India. There may be some people coming from India.
So if family members may be interested in coming from India, of course, there are channels in which they can sign up over in India.
They can buy online there also, no? Online they can.
That's right. They can sign up, get tickets. There is a travel agency located in Mumbai that's assisting individuals.
I don't know the travel agencies may help in buying because they are telling people that they can just go on online
and buy the tickets, right? But they can help buy airline tickets, right? And so of course we hope that all of our friends, maybe our viewers, will join us at the end of April in Tampa for the International Indian Film Awards. It's very exciting. All of our friends are going to be coming in from all over the world, and it's going to be very, very exciting. So we're looking forward to it. If you want to see if there are tickets available, please feel free to go on to Ticketmaster, www.ticketmaster.com, and you can see whether there are any tickets available that way. If you need additional information about IIFA, where it's being held, there is, of course, a website. You can feel free actually to link to our website. I believe that we have a Bollywood website that's linked to our website that also gives the information about IIFA. IIFA has its own website, so you can feel free to visit that site. But again, feel free to pick up the telephone if you are not on the web and give us a call, and we'll be more than happy to provide you with the information. You can simply go on
Google and say IIFA 2014.
214, yeah, exactly. So we look forward to seeing all of our viewing audience joining us in Tampa for nice warm evenings, for several nice warm evenings of Bollywood presentations.
Okay, the H-1B season is over, and some of our viewers have already filed. Their employers have filed the petitions for H-1B visa, and hopefully we pray that you are successful in that, because as we explained in our earlier programs, most of the time our guess is that probably all the numbers may be gone in the first week of April 2014.
Exactly.
But you may be getting, what may happen, I'm asking this question, supposing they still cannot accommodate all the petitions, then they do a lottery program, right? So their lottery program. Now, at what point do they tell the employers who have filed the petitions that your petition did not reach, and then return back the petition and the check that they sent?
Well, if it runs historically, obviously they change the procedures all the time, but if it runs the way it did last year, then probably what will end up happening is that first, receipts will be issued immediately. And again, one of the things we talked about in the past is premium processing. And if you want to know that your case was received, the premium processing receipts last year came out very quickly. They came out within probably about 7 days after the H-1Bs were submitted, whereas the non-premium processed H-1Bs receipts were coming out maybe anywhere between 4 to 6 weeks afterwards. So we had a lot of people on pins and needles waiting to know whether or not their cases were approved. Then what happened was the ones that were not chosen were sent out. Those cases were sent back, and that happened anywhere between 5 to 8 weeks out. So again, premium processing, at least this way you'll know that your case was put in or accepted or not.
So that's a question on the fees on the premium processing, which is $1,225, I believe.
$1,225.
Okay.
Yeah.
Now let's say that I had one question from somebody saying that my employer doesn't want to pay that fee. Can I pay the premium processing?
Absolutely. Individuals can pay that fee. The only fee that's required that the individual is not allowed to pay is the Department of Labor training fee, which if you have 25 employees or less is $750. If you have 25 employees or more, it's going to be $1,500. That's the only fee that the employee cannot pay. Now, the only other nuance...
Filing fees the employer has to pay, no?
No, the individual can pay the filing fees too. The only nuance is that if you have a wage that is very on the cusp of the federally mandated prevailing wage and the individual is picking up this cost, then of course if it drives it below the federally mandated prevailing wage, then you have a situation where the U.S. Department of Labor could argue that that was really an employer cost that should have been borne by the employer, and that pushed it down below the federally mandated prevailing wage. I have to say that in the H-1B cases that we haven't seen that come up because the wages have been high enough so that you don't have anything that's on the cusp. But if you do have something on the cusp, of course, the way to do it would be to just boost up the wage a little bit, and then you won't be dealing with that potential analysis.
No, let's talk about our winners who got their H-1B in and approved.
Right.
Now, where do we go from here? Because they may come to know in the premium processing a decision by end of April. Right. And then the question is they have...
Well, the filing date is April 1st, and again, this is for an October 1st start date. And the winners, of course, they will be notified, as they start to process the cases.
In the premium processing, generally within a month's time it will come.
Well, and remember, Michael, that you're either going to get an approval or you're going to get an outright denial, which we tend not to find is the case. Or you're going to get, which this is the more common result, is what's called an RFE. An RFE is a request for evidence.
Some kind of a response is going to come. That's what I'm saying. By end of April, you have a response. Approval, denial, or RFE.
Exactly.
So let's talk about the approvals. They got their approval, but they cannot start working until October 1st.
Correct. But hopefully most of the individuals then who get those approvals are in OPT, and those OPTs might be expiring in that gap period of time between April and October, and what that does is by operation of law that OPT is automatically extended through October. Okay? Also there might be some permutations where that's not the case.
Those people who change their status from F1 or the F1 who do not have that advantage of OPT, or they cannot go up to the point that is required. I think now they have relaxed the rule. It doesn't matter their OPT is valid whatever time, up to whatever time. Is that correct? I mean, OPT may be expiring somebody's in June or May or June.
Right. So if it's expiring, of course they have the 60-day grace period. But what happens is that if they did not file when they were work authorized, then they can't continue their OPT through October 1st.
Yeah, but they cannot work if the OPT has expired.
As long as the H-1B is approved, they can continue to work in that period of time up to October 1st.
No, I think from October 1st they can work on H-1B.
That's correct.
Prior to that, if their OPT has expired, I think they can stay here until October 1st and start working from October 1st.
That's correct, but they can also continue their OPT.
But if it's already expired, the date, OPT date has expired, I'm saying.
Yeah, but they can still continue they're allowed to continue to work as long as the H-1B is approved.
H-1B. Yeah. So that's a good news for them. But let us say those people that come on a visitor visa and their H-1B has been approved, change of status. So they cannot remain here.
No, while the H-1B is pending, they're allowed to stay. There is a rule which says that if you have filed a bona fide request for a change or extension of status, you're allowed to stay until there is an outcome on that determination.
Let's say that that person's visitor visa expires and H-1B is approved.
Okay.
So they definitely will not get the change of status. Then they will still approve the petition. Okay. Those who are not eligible for
well, the question is, how was that H-1B filed? Because when an H-1B is filed, you have two choices. You can either file requesting consular processing, or you can file requesting the change of status. So the question is, if you filed requesting consular processing and the visitor visa runs out, the idea would be, of course, then don't accrue 180 days of unlawful presence,
that's the point,
because then we get the three-year bar, and we don't want that to happen.
That's right.
So, so the answer would be go home. Wait until about 2 weeks.
That's the point I was making.
Right, exactly. So wait until about 2 weeks before October 1st. Process for your H-1B visa stamp at the U.S. consulate abroad, and then re-enter.
Right.
So or if the individual applied for what's called a change of status in the U.S. and they were in B status, so then probably the government has to adjudicate two pieces of the case.
Yeah.
The first piece of the case is, does the individual qualify for the H-1B? The second piece is, were they in valid status at the time that they filed, such that the government can approve the change of status as of, so the question will be, are they in status on October 1st to be able to take up the H-1B?
Actually, a good lawyer or law firm will look into this issue as to whether this client is eligible for change of status based upon his authorized stay or not, and make the request in the H-1B about visa processing.
Because it's a timing issue.
Yeah, correct.
Yeah.
And even those people that are getting change of status, but they need to travel back home, for example. Remember, they do not have a H-1B stamp on the passport. Right. And some people say, oh, but it's already approved. I had I-94 valid. I'm going to go and come back. And answer is no. You need to get a visa stamp from the consul of H-1B stamp. So when you are going back home for emergency or meeting the parents or vacation or whatever, but some people say, those who change from visitor to H-1B, that my work start is going to be from October 1st. And even if they have a change of status done, they may prefer to go back home and get a visa stamp. And I always recommend them that because they may any time have an emergency to travel back home. And they should do in advance consider that in getting H-1B stamp in the first place. Also, I'm telling you that American consuls do not like people who came on a visitor visa and change their status in US. And after that, they are going for H-1B visa. They don't like it.
That's right.
So ideally, you get an H-1B approval, you go back to India, apply in the American consulate, and get H-1B stamp. The consul will see, nice guy. He promised he's going to go visit. He came back. Of course, he applied to it, but he came back to us for getting H-1B and not changing the status. Little things, but these are important.
No, it's a very important nuance, Michael, and I think that we also, I agree with you 100%. It's better to tell them to go back and get the stamping. And I think it's important for our viewers to know, because I get this question a lot, when you have an individual who's applied for an H-1B with a change of status request, once you decide to leave, it's an automatic withdrawal of that change of status request. So by operation of law, once you depart, that change of status request is gone. Okay? So I think it's important
change of status has been granted. He's already working beyond October, November, December, January. And then he wants to go home.
Oh, and then, so then the consulate looks at that and says, why did you do that? And then,
also, why did you do that? And they want to see whether when he got a visitor visa from us, what was an intention. Some people leave the job.
What was the representation?
Some people leave the job also and pack everything and wipe up, all the, things back home. That means they had. Why did they leave the job? When they were coming on a visitor visa, consul is going to ask the question.
That's right.
That means you had the preconceived intent. And they may charge with them not only denial of the H-1B, with the fraud and Section 6C and the permanent lifetime. But these are very complicated issues, complicated questions. Therefore, we always advise our viewers and the clients that please see a good immigration attorney who understands all this about the processing here, processing back home. There are a lot of law firms who do the H-1B petition, okay, my job is done. They are not thinking about India. They are not thinking about the American consuls, how they will adjudicate that. I mean, we meet the consul all the time, we travel all the time, we have all the information, we have the knowledge and years of experience, how the consular processing is done. So I think it is always a good idea. Same thing happened with the spouses also. People go there and even they have H-1B visa, they go back to get married, and the wife has to apply for an H-4 visa. And H-4s cannot work, obviously, right? But then again, the same questions comes. Where is your husband? How did he get the visa? What kind of work he is doing? Is he still employed in the same location where it was mentioned in the LCA? So these are some of the issues that you should sort it out, discuss, plan it right. Planning before you travel is very, very important.
Exactly. And Michael, now that the H-1Bs are in, for all intensive purposes, we want to remind, of course, our viewing audience to be sure that your employers have public access files. The day after you file the LCA, you're required to have a public access file on the site at the employer's place of business for either the Department of Labor to look at or for the public to look at. It's very important. If you have any questions at all about what needs to be contained in that public access file, please send us an email. We'll be more than happy to provide that information to you.
I think there are a lot of things to talk about, the employer's obligations and the employee's obligations, and
Absolutely.
where things go wrong and where they run into problems. Today's program, we don't have further time, but hopefully in the future, in the upcoming programs, we can talk a little bit more about
Absolutely.
these issues. It's very, very important. David, thank you very much
Thanks
for
so
being
much,
on
Michael.
the program.
Always a
and
pleasure.
thank all of you for watching the program. Please don't forget IIFA. If you still have interest, I believe the tickets are running out very quickly. And thank you very much and goodbye.
Thank you.